Good afternoon, everybody, and thanks for joining us for the kickoff webinar of Conn Maciel Carey's 2019 OSHA webinar series. We're excited to carry on a tradition that's been running now for about 4 years of spending our first webinar of our annual OSHA webinar series talking about what we learned about and from OSHA in the year that's just ended, and then doing a little forecast to look ahead for some of the top OSHA issues to track in the upcoming year, or the year that has just begun. I'm very pleased to be joined today by the partners in Conn Maciel Carey's National OSHA Practice Group. I'm going to have everybody sort of introduce themselves when they take over the microphone and kick off the section that they're going to be discussing as part of the program. Your lines are muted, but if you have questions at any time throughout the program, there's a chat box on the bottom left. Please type in your questions and we'll address them either at that spot or at an appropriate time, or at the end of the program if we have time. I'll introduce myself right now. The first faceless voice you're hearing is Eric Conn. I'm one of the founding partners of Conn Maciel Carey, and I chair the firm's OSHA Practice Group. I've practiced for, the beginning of my career, I practiced for more than a decade alongside the first General Counsel of the OSHA Review Commission, and have been representing employers for my entire 19-year career in matters involving the Occupational Safety and Health Act and the standards promulgated under the Act. I work with employers to manage inspections, investigations, and then primarily litigating against OSHA in enforcement actions, as well as working with criminal counsel and other counsel on matters involving criminal investigations or significant civil actions related to workplace safety and health. I'm joined today by my partners, Amanda Walker down in Atlanta, Georgia, Kate McMahon and Micah Smith here in Washington, D.C., Andrew Summer, who heads our Cal OSHA practice out in San Francisco, and Erin Gelb, who heads our Midwest OSHA practice out of our Chicago office that is celebrating its 1-year anniversary right about now. And they will introduce themselves as they kick off their sections of the program. So as I said, what we're talking about today is 2018 in review. What were some major developments at OSHA over the course of 2018? And then what are the top 5 issues that you all should be paying attention to, and that we will certainly be paying attention to in 2019 at OSHA, or that affect workplace safety and health? So we'll start off. I'm going to do the 2018 in review, and then my partners will be prognosticators and will tell you what we expect will be the hot issues at OSHA over the course of this year. So, 2018 in review. The first thing that was sort of most interesting about OSHA in 2018 was one of the major developments that did not happen, and that was that over the course of a full calendar year, and now nearly 2 years into the Trump administration, there is still no Assistant Secretary of Labor for OSHA. Scott Magno, who is the former Vice President of Safety at FedEx Ground, was nominated by President Trump to be the head of OSHA back in 2017. So this should not even be a 2018 discussion, and hopefully it will be a 2019 discussion, but we'll figure that out when Amanda talks about the future of OSHA in that regard. But what we've got right now is that in 2017, Mr. Magno was nominated by President Trump to run OSHA. He was approved by the Senate Help Committee, but did not get a vote by the full Senate before the end of the congressional term that ended at the end of 2017. So his nomination returned to the White House, and President Trump nominated Mr. Magno again to head OSHA very early in 2018. That nomination was again cleared by the Senate Help Committee also very early in 2018, and then for the entirety of 2018, that nomination sat waiting for a full vote of the Senate and was never called for a vote. Now there is, some blame to go around throughout Senate. The Democrats in the Senate have put up a big fight about any nomination to any position made by this White House, and they have basically, not agreed to a cloture vote, which would avoid the requirement to have 30 hours of Senate floor debate time for every, Senate-approved level nomination. Unless they got something really juicy in exchange. So very few Senate-approved nominations have gone through, and then you go to the Senate Republican side, and it's really, they're doing the analysis of what positions, what nominations are worth the things that they're having to give up to get people confirmed. And so far, for whatever reason, the Senate Republicans have not found a head of OSHA to be a high enough priority to give something away or to commit 30 hours of debate time on the floor of the Senate. So no vote has happened, and this is surely a confirmation that would be easily approved if the vote just happened, but it just hasn't yet. So 2018 came and went. A congressional session ended again at the end of 2018. So technically, right now, there is no nominee for Assistant Secretary of Labor for OSHA. Everyone fully expects that Mr. Magno will be renominated again by the White House. But then there's big questions of whether, whether a vote will ever happen, whether he will accept the nomination, whether he will continue to wait as he has. And Amanda will talk about that in some more detail later. So that's, this sort of big vacuum. We are now the longest ever vacancy in that position, with an acting assistant secretary who is the deputy assistant secretary confirmed that did not require Senate approval in that job right now, basically running the agency without a lot of help in the front office, with no special assistants, with no chief of staff, and then again, obviously, no assistant secretary. So that was the big, the big development was a non-development in 2018. The other thing that I'm sure everybody is paying a lot of attention to is what's going on with OSHA enforcement in 2018. We all had expectations, and I think we talked about this same discussion probably at the beginning of 2018, was how have our expectations about OSHA enforcement matched reality. So our expectations under a Trump administration has been scaling back of enforcement, focusing resources much more on compliance assistance, revisiting and either eliminating or revising enforcement policies that had been implemented by the Obama administration's OSHA that drove a big increase in civil penalties, a big increase in enforcement generally. Surely we expected that, based on the campaign rhetoric about deregulation and about sort of getting government out of employers' way to help grow the economy, we expected to see a big clamping down on enforcement. Specifically, I expected to see what was, at the end of the Obama administration, 9 active national emphasis programs and about 150 active regional and local emphasis programs, which was probably about 10 times higher than we saw during the Bush administration. And one of the ways that we expected to see a big clamping down on enforcement was very significant budget cuts at OSHA, as well as sort of a realigning the budget to focus resources and personnel on compliance assistance and away from enforcement. We talked about in this same presentation at the beginning of 2018, that our expectations had not been met, that in fact enforcement was still considerably, it basically looked like we were still in the Obama administration in terms of what OSHA enforcement looked like. Well, now we're 2 years into the Trump administration. How has enforcement matched up with our expectations? Well, again, I would say it feels like we're now moving into year 11 of the Obama administration. We continue to see essentially the exact same number of and exact same nature of local and regional emphasis programs. We still have exactly the same number of national emphasis programs, including one new one. The Chemical and Refinery Process Safety Management National Emphasis Program has kicked off under the Trump administration. And then we saw the Trump administration announce a new very significant enforcement program, the Site-Specific Targeting Program, a program that had been retired during the Obama administration, was sort of the grandfather of all emphasis programs for programmed inspections, and that is coming back now, and the agency will be using 300A data collected under the e-record keeping rule to target enforcement resources, and Erin Gelb is going to talk about that in more detail, what that program is all about. So this is one area where we've not seen our expectations met about what OSHA enforcement will look like. How about budget? Budget is exactly the opposite of what we expected. Not only has the Trump administration not slashed OSHA's budget and shifted things around from enforcement to compliance assistance, we've actually seen OSHA's budget grow. A $5 million increase in the budget that was just approved for the Department of Labor, for OSHA specifically, for fiscal year 2019, $5 million increase over the budget for fiscal year 2018, $9 million more even than the President requested. We've also seen for the first time in about 5 years an increase in the budget for state OSHA programs, allocating now $103 million to the states out there, about half of them that operate their own federal OSHA-approved state OSHA program. And you can see in this chart here, small, but you can see the full-time employees, the count is not decreasing. It's staying pretty steady for enforcement personnel and personnel at OSHA generally. So again, expectations not being met. Another area where I sort of expected to see a change was in OSHA's penalty authority. You'll recall that back in 2016, OSHA got a gift from Congress as a way to bargain their way out of one of the government shutdowns during the Obama administration, was an agreement to raise civil penalty authority for all federal enforcement agencies to catch up to inflation since the last time that agency's penalties were updated. And OSHA had sat still, their penalty authority had sat still for longer than I think any other agency in the federal government. And so when this catch-up provision was put in place, OSHA's penalties went up by about 80%. There was also, as part of that agreement, a requirement for the agencies to increase their penalties every year to keep up with inflation, tracking the consumer price index each year. I sort of expected that when you had a Republican, particularly President Trump, and the way he has talked about getting agencies and government out of your hair, along with a Republican House and a Republican Senate, that they would revisit that statutory requirement to increase penalties every year. But there has not even been a bill introduced in either house that would stop these annual increases. So in January 2018, we saw another bump in OSHA's penalty authority, and I think Erin, again, talking about enforcement in 2019, will talk about what to expect in that regard as well. But we've continued to see penalty authority increase, and let's talk about how we're continuing to see OSHA utilize their penalty authority. OSHA inspections, more or less the same number in 2018 as in 2017, and that number, again, is bigger than the number of inspections conducted by OSHA in the last year of the Obama administration. So if you expect, and frankly, the number of inspections being conducted by OSHA was trending down every single year for President Obama's second term in office, and then all of a sudden, during the start of the Trump administration, when you expect a big drop-off in OSHA enforcement, actually inspections increased, and they continue to be at a level higher than the final year of the Obama administration. Another enforcement surprise. Total violations issued, that number is actually a little bit lower than the number during the Obama administration, but again, continuing a downward trend. And here, basically the same number in 2018 as in 2017, but a little bit lower than the end of the Obama administration. We'll talk, though, about how despite a lower number of citations being issued, penalties and fines have kept up, and in fact, in a lot of ways have exceeded what we were seeing during the Obama administration. I include this slide every year because I find this number to be fascinating as an OSHA defense lawyer and someone who participates in OSHA inspections, all day, every day of the year. That it continues to be an extraordinarily high percentage of cases in which an inspection is conducted that citations are issued, or I guess I should say an extraordinarily low number of instances where an inspection is conducted and no citations are issued. And we continue to hear stories from out in the field, and I've heard it myself from the mouth of inspectors that, hey, I've got to cite something to prove to my boss that I was here. This shows you that regardless of administration, Republican or Democrat, it is very, very difficult to have a clean OSHA inspection. Here's where it gets interesting, though. Average penalties per violations have increased considerably. There was a commitment by the Obama administration, Obama's OSHA, that they were going to triple the level of penalties issued with associated citations, and they accomplished that goal, going from less than an average of $1,000 per serious violation to up over $3,000 per serious violation. Well, that number has grown even considerably since then during the Trump administration. Obviously, this has a lot to do with the new penalty authority, that OSHA's maximum civil penalties have increased by a little over 80% now. But this shows you that OSHA is using that penalty authority. And if you thought that a Trump administration was not going to use that authority or was going to use kid gloves for OSHA enforcement, our expectations in that regard have not been met. And as a result of that, and again, this is the one where I was probably most surprised that last year, fiscal year 2017, OSHA set a record for the most $100,000 plus enforcement actions the agency had ever issued in the history of the agency. Donald Trump's OSHA was the most rigorous OSHA enforcement the agency has ever carried out. 2018, that number dropped a little bit, but it's still in the top 5 $100,000 plus enforcement actions in the agency's history. On average, now 2 years through the Trump administration, they're averaging nearly 200 $100,000 plus enforcement actions every year, as compared to about 165 $100,000 plus enforcement actions during the Obama administration. So an interesting and surprising development there. Another area where perhaps we expected to see things ease up on employers, where our expectations have not been met, is in the heavy use of repeat violations. During the Obama administration, major changes were made to policy to find and cite more repeat violations in a very deliberate way, because those violations carry 10 times higher penalties. Well, fiscal year 2017 saw that number continue to increase up to 5.5% of all OSHA citations issued were now characterized as repeat violations. In fiscal year 2018, that number dropped slightly, but still higher than 5%, which is the third highest percentage of repeat violations in the agency's history, only the third time it's ever been more than 5%. So real quickly to wrap up for 2018, I want to talk about, I think it's 3, maybe 4 significant cases that were decided in the realm of workplace safety and health. And since we were just talking about repeat violations, let's start there. In a big case that was decided by the Second Circuit in February of 2018, the Triumph Construction case. One of the ways that Obama OSHA's increased repeat violations by such a significant percentage was they changed what's called a look-back period. It used to be for many, many years that OSHA would look back 3 years for past violations on your record to serve as the basis for a new repeat violation. That's a policy, and if you look in OSHA's field operations manual, it's where you find what the look-back policy is. Obama's OSHA changed that policy to expand the look-back period to 5 years. So instead of 3 years, 5 years means there's a longer period that you might have an old violation on your record to serve as the basis for a repeat violation. Well, there was some fight in a case by Triumph Construction whether it was appropriate to look back more than 3 years in their particular case. And lo and behold, despite the fact that President Trump took office and President Trump put his people in place at the head of the Solicitor of Labor's office, and they took over this case, the Department of Labor continued to fight for, in defending that case, that not only was 5 years appropriate under the policy that Obama's OSHA put in place, that in fact ignore those policies. We can look back as far as we want. We can go all the way back to the birth of the agency in the mid-70s because the statute does not limit our look-back period. And the Second Circuit OSHRC and the Second Circuit agreed that OSHA is not bound by any stated look-back policy because the Act does not create any such limit. So basically, we've created now unlimited look-back periods for repeat violations. OSHA still maintains in its field operations manual a 5-year look-back policy, and they will follow that policy when they want, and they'll ignore that policy when they want. So it'll be interesting to see how they use this now confirmed unlimited look-back period. But that was a big deal, a big case that was decided in 2018. Another big case in 2018 was the Marjack Poultry case that was decided by the 11th Circuit. And this was a case in which OSHA expanded an unprogrammed inspection. So OSHA was inspecting this poultry facility because of a reported hospitalization. In the course of that inspection, OSHA did what it does in every inspection. They asked for a few years of the employer's 300 logs, and they observed on those 300 logs a handful of slip, trip, and fall injuries, a handful of ergonomic injuries, a handful of other types of injuries, not significant numbers, but there were injuries on the logs. And OSHA said, hey, you know what, there's an active emphasis program targeting the poultry industry, and we're seeing some injuries on the record-keeping logs. We would like to expand this inspection from a targeted, very narrow injury inspection to instead be a wall-to-wall comprehensive injury and illness inspection under that emphasis program, or just more broadly because we've observed injuries on the logs. The employer moved to quash, so the employer refused to consent and said, we'll consent to an injury inspection of this one location and this one work activity, but not this broader wall-to-wall inspection. OSHA got a warrant, and it was issued by a magistrate judge that was written as broadly as OSHA requested. The employer moved to quash that warrant and was successful at the lowest court, at the lower court, and at the appeals court. The 11th Circuit agreed to the judge's decision to quash the warrant because they said information on a 300 log does not establish reasonable suspicion, because the existence of an injury, the fact that there were 7 injuries, does not mean that there is necessarily a violation of an OSHA standard. You will recall that the OSHA injury and illness record-keeping standard is intended to be a no-fault regulation, that things are recorded on your injury logs, whether they are the result of a deficiency of your safety program, whether they're the fault of the employee alone, whether they're just natural, God has bestowed that this accident will happen, regardless of whether it's the result of a regulatory violation or some deficiency in your safety program. So the mere existence of an injury does not create probable cause to expand an OSHA inspection. And the court said, look, it's only 7 injuries at a facility, 7 injuries over 3 years at a facility with over 1,000 employees and I don't know how many million man-hours worked. That's actually, not only is that not a sign of reasonable suspicion or probable cause of a violation, that's actually a pretty good record. So OSHA was pushed back on their effort to expand inspections. It'll be interesting to see if other employers follow suit, or if OSHA, does OSHA continue to try and expand inspections, and do employers follow suit and try to push back when that does happen. Real quickly, one other significant case here was the about OSHA's multi-employer enforcement policy. The Fifth Circuit was a lone circuit in the country that had said, hey, we don't buy this multi-employer enforcement policy. OSHA liability should extend only to an employer's own employees, so you should not be cited if your own employees are not exposed to a hazard, which is, the opposite of OSHA's multi-employer policy that says if you're a controlling employer, a correcting employer, a creating employer, you can be cited even if your own employees are not exposed to a hazard. Despite the Trump administration taking over control of what cases they litigate and what positions they take in litigation, they continue to fight against that old Fifth Circuit precedent, and the Fifth Circuit overturned its own precedent in a case involving Hensel Phelps Construction and granted deference to OSHA's interpretation of the OSHA Act that allows them to cite employers even when their own employees are not exposed to a violation. So now the entire map, everywhere in the country, there is no circuit precedent that says the multi-employer policy is unlawful, so OSHA can enforce this everywhere. One other case that I thought was very interesting because we worked on it and we were successful in it, and so I want to tell you about it, was one thing we saw over the course of the Obama administration was an expansion of OSHA's use of its egregious policy, or its per instance citation policy. And they began to do this by getting creative about the types of standards that would support per instance violations. And it has always been, and there's a lot of case law out there that establishes that OSHA may only cite violations per instance, meaning per employee, per machine. For every employee not wearing a hard hat, there's an individual violation of the PPE standard. There was clear case law that says the language of the standard must speak in very clear terms about an individualized duty, that the duty must run to an individual employee or to an individual machine, a duty to train each employee. You would see language like that in the standard. Well, OSHA was looking for ways to ratchet up their penalties, so they started to get creative about the standards that they believed use that kind of language to support per instance violations. And in one case that we were involved in, they cited an employer for per day violations of a standard that requires, it's in the grain standard, that requires employers to lock out all equipment that presents a danger to employees in storage structures before entries into those storage structures are permitted. The standard clearly talks about categories of equipment, employees generally as a group, storage structures generally as a group, clearly no individualized language in there. But OSHA cited, in any event, 3 consecutive willful violations for 3 straight days of entries into a bin. We filed on behalf of that employer a summary judgment motion, which was granted by the review commission, saying, sorry OSHA, you just don't have that authority. The standard does not clearly allow for multiple units of violation. You could abate this by a single act. You lock it out once before the first entry, keep it locked out for 3 straight days. One act would have abated all 3 violations. Oh, and by the way, the OSHA Act itself tells you the only circumstances that per day penalties are permitted is for failure to abate violations. So this is not a lawful use of the per instance policy. OSHA was pushed back in their effort to get creative and cite more egregious violations, and we are very proud of that outcome. Last thing I would say, and that Micah Smith is going to talk a little bit more about in big cases coming next year, is that not in an OSHA case but an EPA case, EPA tried to delay the effective dates of the major RMP amendments to the RMP rule, which is a sister regulation to OSHA's PSM requirements. Obama's EPA promulgated major changes to the RMP rule in the final days of his administration, of his second term. EPA under Trump moved to delay the implementation of those amendments while they engaged in a new rulemaking to rescind most of those requirements. There was litigation about whether it was lawful to delay that rule, and the D.C. Circuit declared that EPA could not delay that rule, or that they had not presented legitimate reasons under the Clean Air Act to support delaying that rule. And so the elements of that rule have gone into effect, or some of the elements have gone into effect because the effective dates are actually on a rolling basis. Some have already gone into effect while EPA works furiously and fast to finalize the rescission rule. We anticipate some litigation there that Micah will talk about. So that is it for 2018. It was, probably a little bit different than we expected, but very interesting and very exciting, and we anticipate more of the same in 2019, and I'm going to turn it over to Amanda to talk about the first of the top 5 issues that you all should track in 2019.
Thank you, Eric. Thank you, everyone, for joining us today. I'm happy to be here and participating in this webinar. Just a few words about my background. My name is Amanda Stranis-Walker, and I am based out of Atlanta. And I am one of the few attorneys who has focused exclusively on occupational safety and health issues my entire legal career. I started at OSHA as a special assistant to the assistant secretary and moved over to the solicitor's office before making my way to private practice, where I've been for nearly 10 years. And in private practice, helping clients deal with all sorts of occupational safety and health issues, whether it be compliance, inspections, enforcement, all aspects of it. Turning now to the topic to be covered today, the new political landscape. As I was thinking about what to say about this, I was hoping that we would have more to report, but let's just check in on the current status. Getting a lot of questions with regards to what the current status is with OSHA due to the government shutdown that's been all over the news headlines. Unlike other government shutdowns in recent memory, this one's a little bit different in the fact that some departments are funded while others are not. It just so happens to be the Department of Labor had its appropriations bill passed in September before the November elections, and OSHA is housed in DOL. So OSHA has its funds. It is operating pretty much business as usual. We're seeing informal settlement conferences proceed, inspections start. There's somebody at the other end of the line when you call OSHA. There are some impacts that OSHA is encountering due to the government shutdown, largely due to the other agencies that they work with. For example, Eric had mentioned the new proposed penalty amounts that go into effect at the beginning of every new calendar year. That has not gone into effect because they are required to post them in the Federal Register, and Federal Register is part of the General Service Administration, which did not have a appropriations bill passed and is still pending. So since they can't publish them in the Federal Register, the new penalties have not gone into effect. Other impacts, there's a lot of vacancies at OSHA, and I'll talk a little bit more about that in a moment. But OMB is also one of the agencies that was not funded, and the Office of Personnel Management. So a lot of the SES packages that have to be reviewed there, and a lot of the higher level of staffing within the agencies has to go through that division, and they are furloughed at this point. So there's certainly some impacts, but for the most part, what employers see on a day-to-day basis with regards to inspections and compliance assistance is moving forward. The Chemical Safety Board is shut down, and also 13,000 EPA employees are also furloughed. So there are some impacts, but OSHA, like I said, is running normally. A lot of questions have come in with regards to record-keeping submissions. OSHA's portal's up, and 300A submissions are still being accepted and are still due by March 2nd. So that's just one question that's come in to me regarding the shutdown, and just wanted to pass that along. Turning to the next slide, House Oversight. Going back to the appropriations issue, OSHA is funded through September of 2019. So then if an appropriation bill isn't passed before then, starting October 1st, there could be a funding issue with OSHA, but it is on solid ground until September, the end of September 2019. House Oversight, another topic that has been newsworthy lately is the change in control in the House. Democrats won the majority of seats in the November elections, and that means that all the committees go to the Democrats. There's more Democrats right now than Republicans, so there's a vast change with all committees. Whoever controls the chamber gets the majority of the staff and the leadership positions on those committees. and gets a lot of say on how they're run. The Democrats have indicated that they're going to use that newfound power to exercise their oversight authority. We've heard a lot of communication and talk about the House Committee on Education and Labor, and in particular the Workforce Protection Subcommittee exercising its oversight authority over OSHA. To date, we haven't seen too much of that, but it's very early. They're still working out their committee assignments. There is a chair for the Ed and Labor Committee, who is Bobby Scott from Virginia, but at this point we do not have a subcommittee chair for the Workforce Protection Subcommittee. I think that'll probably be worked out in the next couple days. They're also staffing up and kind of just getting everything in place to get the oversight engine started. Oversight, having been in a prior administration when Congress changed and oversight was a big impact, it is a lot of work. It is a lot of requests for documents, memorandum, just a variety of different things, and it can also entail committee hearings, and it just puts a substantial burden on the agency to respond to Congress. And there's subpoena powers and being contempt, which nobody wants to get in those circumstances. So usually there's a very diligent effort made to comply with those requests when they do have the oversight authority. Senate also has oversight authority, but you generally don't see the Republican Party exercising it as strenuously when you have a Republican in the White House. And that works the same way if you had a Democratic Senate and a Democrat in the White House. So we expect OSHA oversight to ramp up. We still haven't seen it too much at this point, but I think it's going to be coming shortly. Some of the issues that they've indicated that they are looking at is the implementation of this administration's deregulatory agenda. Some things as Silica, beryllium. There's been a particular focus on the record-keeping rule that went into effect in late 2016 with regards to collecting data on the Internet, and there's been a notice of proposed rulemaking to modify that. All subjects that are likely to be discussed in a committee, and also enforcement activity and staffing, I think, will also be a big focus of their oversight interest in OSHA. So all to come in 2019, and something to look out for. As Eric talked about, OSHA has not received a confirmed assistant secretary since Trump took office in January of 2017. A gentleman by the name of Scott Magno was nominated for that position back in October of 2017, and it is he has gone through the process twice. He was nominated twice, went through the committee twice, and then in both instances his nomination languished on the Senate floor. Has no real relationship to do with his credentials or his ability to lead or any substantial controversy. It has to do with political implications. As Eric mentioned, Democrats have required 30 hours of Senate debate on his nomination, and the Senate has not decided that that's how they want to allocate their Senate floor time. They've put more focus on federal judicial nominations as well as other higher level confirmed positions. And I think that'll probably be the case for the near future. For example, I just wrote down a few minutes ago, I think Defense, EPA, DOI, Department of Interior, and DOJ, we got hearings going on today, are still waiting for their lead confirmed secretary or official. So those vacancies are open. So there's not been any discussion with regards to his renomination for a third time for the position at OSHA, but Eric indicated it's likely. It's something that's under consideration, and I'm sure that we will be hearing about that shortly. And I think it's kind of not having an assistant secretary kind of has put some obstacles in the way of OSHA. They've been waiting for an assistant secretary to staff up on some of their career positions. There's a lot of vacancies throughout the agency. I just did a count, and over half of all their senior management is in an acting position waiting for some sort of direction from assistant secretary or otherwise to get confirmed spots. So certainly leaving the agency a little bit without clear direction, without an assistant secretary. And turning to the OSHRC, the Occupational Safety and Health Review Commission, one point of stability within the OSHA world. The commission is fully staffed at this point. It has its 3 commissioners, which has been a rarity over the last 10 years. They are all appointed and they serve terms. I don't know who has the next term up, but I don't think that any terms expire this year. They are funding and they're open for business as normal. So decisions are being written, ALJs are handling cases as normal. And we do expect, typically the OSHRC Commission is made of 2 appointees that are of the party of the president, and then who's out of the White House gets 1 appointee. So we have 2 Trump-appointed appointees, Heather McDougal and James Sullivan, and Cynthia Atwood was appointed over in the previous presidency. So with 2 Republican-leaning commissioners, we expect more employer-friendly decisions, and we're starting to see that materialize, but it takes a little while for the cases to make its way through the system. That is a brief overview of the political landscape that we're dealing with in OSHA world, and I'm going to turn it over to my colleague.
Hi, Amanda. This is Erin. Can you hear me, hopefully?
Yep, very
Eric,
good. We hear
great.
you.
All right. Thanks. Some technical difficulties from Chicago. As Eric mentioned at the start, I joined the firm pretty much a year ago, maybe a year and a week ago, and I'm handling all manner of workplace safety and health matters in the Midwest. I've been a management side employment lawyer for the past 25 years, much of that doing employment litigation and OSHA as well. As I like to say, some days I'm defending workplace OSHA inspections or investigating fatalities. The next day I'm defending the deposition of an accused harasser, and most days I'm doing both. And it's been a great year, whirlwind, and I'm super excited to be part of the team. So let me just jump right into the first issue, civil penalties increasing again. I think this is something that every employer is concerned about, certainly the bottom line. And if you joined our prior annual updates in years past, you know that the maximum penalties have increased each year since the catch-up that Eric referenced earlier, including in January of 2018 and again coming this year. And as Amanda mentioned, obviously that's delayed in the implementation due to the shutdown. But you can certainly expect once, assuming the government reopens, not sure when that is going to be. I think most of us are hoping that it will be sooner rather than later, at least those of us that fly and are hoping that our planes are being inspected. You can expect to see the maximum increases or the maximum penalties increasing for other than serious and serious citations, passing the $13,000 threshold to $13,219. Obviously, the bigger impact on willful and repeat citations with another 2.2% increase with a potential maximum penalty of $132,182. So if you look back to the historical maximums in those areas, or those types of citations of $70,000 each, we're inching closer to essentially doubling what they had historically been. And last but not least, failure to abate citations will soon be citable up to a penalty of $13,219 each day. I think one of the more specific or significant developments, now that the stakes are higher with greater penalties, I'd like to talk about the likelihood of OSHA showing up at your work site, even if you don't have a reportable accident or an employee complaint. We recently published a blog article about this. I certainly commend it to everyone to dig deeper into the site-specific targeting inspection plan. But last October, OSHA announced the SST-16 inspection plan, again, a site-specific targeting inspection plan for non-construction workplaces that have 20 or more employees. The plan is based on calendar year 2016 300A injury and illness summary data that employers are hopefully submitting or have submitted to OSHA via the injury tracking application. also known as the e-record keeping portal, in December of 2017. It's important to keep in mind with respect to SST, you shouldn't be surprised by this. This is not a novel program for OSHA. Indeed, SST was, as we like to say, the grandfather of all OSHA enforcement emphasis programs. Before 2014, SST programs used illness and injury information collected under OSHA's former data initiative to target the agency's inspection resources. So then it's important to understand which employers will be at risk for an SST inspection. The SST-16 plan selects establishments for inspection based on, again, their calendar year 2016 data, and OSHA has created software that will generate a list of targeted establishments for enforcement from this data. And those targeted establishments will be those with a days away, restricted, or transferred, also commonly referred to as DART injury rates, above some yet undefined threshold, together with a random sample of other establishments. We don't know specifically what those target thresholds will be, but we can expect different DART rates for manufacturing and non-manufacturing establishments being set as selection criteria to achieve what is, in essence, a 50-50 representation on the list. And again, although those triggering rates are unclear still at this point. Anecdotally, we've already seen, at least in my practice, I've seen a number of clients that have already, where OSHA has already initiated SST inspections. And in each instance, they've referred to, although not shared, what the injury rate, what the threshold is that they're looking at. OSHA representatives have also indicated that the agency is waiting to see how large the final list is before setting DART rates for manufacturing as well as non-manufacturing establishments. In addition to those employers with DART rates above the industry threshold, SST inspections will be opened at a random set of establishments that the agency believes were required to submit 300 injury data under the e-record keeping rule but did not. And the agency will also open SST inspections at a random sample of establishments with unusually low injury reporting rates. They say that they're doing this for quality control purposes and to identify possible under-recording. So in essence, congratulations if you're doing your job well and you've got a below industry rate, you may well find yourself dealing with an SST inspection. Perhaps the most important aspect of the SST inspections, and if you remember nothing else about this topic, it is that these inspections are comprehensive in scope. So in other words, they're in essence wall-to-wall inspections. And this means that you likely don't have the same ability to push back or limit the scope of the areas that OSHA inspects or the documents that they are insisting that you produce. Certainly if you've listened to any of our presentations on managing inspections, we always emphasize the importance of managing the scope, trying to limit it as much as possible. That's not really an option with respect to SST inspections. Also note that SST inspections will be coordinated with OSHA's emphasis programs. Eric talked about the number of emphasis programs during his portion of the presentation. We still have the full range of emphasis programs. There's been the new national emphasis program that he referenced. There's also been some regional emphasis programs that have been launched. If you end up with both of these at the same time, this means that if an establishment is covered by an emphasis program and you happen to be selected under SST-16, the SST inspection and the emphasis program inspection will run concurrently, although they'll be classified separately. There are some exceptions to the site-specific targeting program, and employers will be deleted from the list that's compiled if they are out of business, which probably should not become as a surprise to anyone, but also can be removed from the list if you've received a comprehensive safety and health inspection within the last 36 months, if you're part of the VPP or SHARP programs, or if you're a public sector employer. Another example of the agency's ramping up of enforcement efforts is found in its use of the general duty clause, particularly with respect to ergonomics, workplace violence, heat stress. I know we're all tracking cases that are pending before OSHRC, both with respect to workplace violence and heat stress, as well as chemical exposures below the permissible exposure limit. For workplace violence, although OSHA is currently citing employers for workplace violence under the General Duty Clause, the agency has started the process of developing a standard for workplace violence in the healthcare and social services sectors. It's published a request for information in 2016 and has set a March 2019 timeline for the next step in the rulemaking process as part of the fall 2018 regulatory agenda, although of course that could still change. It's also noteworthy that Representative Joe Courtney, a Democrat from Connecticut, has said that he plans to reintroduce legislation that he introduced during the last session of Congress that would require OSHA to issue a final rule requiring employers to craft violence prevention programs. This would require employers to work with their employees to develop this program and prohibit retaliation against employees who report workplace violence to an employer, law enforcement, or a government agency. Whether the OSHA rule moves forward or Representative Courtney's legislation proceeds, these efforts show and really emphasize the importance of the workplace violence issue to OSHA and that the agency is likely to continue to prioritize this issue in its enforcement efforts through the use of the General Duty Clause. So if you are an employer particularly that operates in the healthcare field, social services, it's imperative that if you've not already done so, that you make efforts to demonstrate or roll out policies and procedures, training, and conduct the necessary assessments to determine and address any issues that you may have in this area. And then another area where enforcement appears to be expanding, you'll notice the theme, that is OSHA's use of the General Duty Clause to cite employers where chemical exposure occurs, even if it is below the permissible exposure limit. The General Duty Clause, for those of you that are aware of it or have been cited under it, essentially requires the agency to establish that the employer failed to keep its workplace free of a hazard to which employees were exposed, that the hazard was recognized, that the hazard was causing or was likely to cause death or serious physical harm, and that there was a feasible and useful method to correct the hazard. And the significance here is in November 18th of last year, that OSHA's Directorate of Enforcement Programs issued a memo to the field, in essence providing that if evidence is collected during the course of an inspection that meets the elements of the General Duty Clause violation, the agency can cite the employer for exposure to air contaminants even if it's not covered by a PEL, and if only some of the elements are met by evidence collected in the inspection, that OSHA should then issue a hazard alert letter. Moving on to OSHA's relatively new Silica standard, I'd like to share some trends and data with you all that we think is helpful as far as understanding how OSHA is enforcing this, again, relatively new standard. We found that OSHA is most likely to cite manufacturers for risk assessment issues. Of the 42 Silica citations issued by the agency, either by federal OSHA or state plans, I should say, as of January of this year, 38% are for not meeting the assessment requirements. Other common citations include lack of a written exposure control plan and training workers on avoiding inhalation. The good news, however, is that most of the fines that have been issued to date are low. Of the 42 Silica citations, 62% have proposed fines of $500 or less. It's also notable that most of the inspections that have been opened with respect to the Silica rule have been based on employee complaints. With respect to Silica, understand also that employers must use engineering and work practice controls to reduce and keep employee exposure to respirable crystalline silica to or below the PEL unless the employer can demonstrate that such controls are not feasible. If feasible engineering and work practice controls are not able to reduce employee exposures to or below the PEL, then employers must still use feasible controls to reduce exposures to the lowest possible level and then use respiratory protection along with those controls. Last but not least, we wanted to highlight for you all that OSHA perhaps like many of your children, have been taking an interest in drones. Last May, the agency issued a memo to the field that area offices may use drones during inspections to collect evidence, including in areas that are inaccessible or dangerous to the co-shows. The agency may also use drones for technical assistance or in an emergency or for compliance assistance. Now, before you start worrying, OSHA will not, and I want to emphasize this, will not be using drones to conduct covert surveillance. The agency must obtain your consent to use the drone, and they must notify you. Well, yeah, that goes without saying. I've had this come up in a very recent inspection, and I think it's somewhat of an instructive example. The co-show reached out by email, asked whether our client would consent to the use of a drone. We went back and forth. We ultimately agreed to allow OSHA to do so. We had discussions on our side about that, and then when we show up for the site inspection, and they were coming regardless, I asked about the drone, and the co-show just said, oh, well, we decided not to do it. It's too much work. We had to file papers with the FAA. We had to do this, and we had to do that, and we had to get this person to sign off on it, and they ultimately decided not to use it. But as Eric says, I am suspect and reserve judgment as to whether OSHA is not going to will abide by this and not conduct kind of covert surveillance.
And this is Eric. Just to share, like, why I'm a little suspicious of it is we all know that in the past OSHA has, they climb up to the top of a building across the street from your construction site and hang out there for a couple hours, filming your workers and taking photographs of people not wearing fall protection or not covering holes and things like that. And the idea is they're in a location where they're allowed to be, basically a public place of public accommodation, and they don't need to give notice to the employer that they're there because they're not on their property. And if they can observe conditions from across the street on top of a hotel or some other building, why couldn't they take a drone up in the sky, not over your property, not directly over your work site, but observe things from up there just like they do in the building across the street? I would not be surprised at all to see them expand or push the limits on that idea of seeking consent, just like they have done in other circumstances.
Yeah, and I think that's the rub. I don't think we'll see them over your operations, your property, quote, in your airspace. But I agree. I wouldn't be surprised if they did not use it in an adjacent area, particularly if that's public land or public property. So with that, I will turn it over to my colleague who's going to cover the status and future of deregulation in 2019.
Good afternoon, everyone. This is Kate McMahon talking to you from Washington, D.C. I want to talk for just a few minutes about what we're seeing in the area of rulemaking at OSHA. By way of introduction, I have spent the last 20-plus years working in the fields of environmental and OSHA law, and have spent much of that time working on OSHA rulemakings. Few and far between they are, but when they happen, they're very, very significant to a lot of stakeholders. Many of you are probably on the phone who deal with OSHA regulations and every day, and so I've been part of a group of people that work with the agency representing industry to do our best to ensure that the regulation comes out looking acceptable to industry. Let me talk about what we're seeing. We are 5 days shy of the 2-year mark of President Trump's inauguration. And, to sum it up, and then let me dig in a little bit. To sum it up, we are seeing no clear sign of unadulterated deregulation as we understood we would see from when when candidate Trump was talking about what he expected under his presidency. I think probably the most significant statement that was made, hold on, let me move these slides here, during the campaign was by Steve Bannon, President Trump's aide-de-camp. And in talking about rulemaking and regulation, he made the infamous quote, if you look at these cabinet appointees, they were selected for a reason, and that is the deconstruction. The way the progressive left runs, if they can't get it passed, they're just going to put in some sort of regulation in an agency. That's all going to be deconstructed. Well, I'm here to tell you 2 years into the presidency, we are not seeing anything like that. What we're seeing, I think, is more of a mixed bag. It's certainly different than, I think, what we saw under the Obama administration, but not that much different. Looking at the fall regulatory agenda issued by the Trump administration, regulatory agendas are issued twice a year, in the fall and in the spring, and they outline for the public what the agency's priorities are, what their rulemaking, active rulemakings are, what the stage that those rulemakings are in, and you get a sense from that document, although it changes all the time, you get a sense from the document as to what the agency's priorities are. This is, we've got a slide here that shows you the agency's 2018 regulatory agenda. Looking at that agenda, what we see basically are about 21 items that have been identified by the Trump administration, Department of Labor, OSHA in particular, that the agency is working on. Some in the pre-rule stage, some in the proposed rule stage, and some close to being finalized. Take out, one of them, which is just a review of the Puerto Rico state plan, and you've got 20 active rulemakings. Looking at those rulemakings specifically, I think we can take 2 out as just sort of neutral, not pro-regulation and not deregulation. That leaves us with 18 active rulemakings. Of those 18 active rulemakings, I'd say 3 are deregulatory in nature. That leaves 15 regulations that the agency is working on that are designed to enhance protection of workers, and that will certainly pose compliance obligations on industry. If I did a check back and I looked at the Obama administration's regulatory agenda at this exact same time, which was fall of 2014, 2 years into his second term. That regulatory agenda looked amazingly similar to this regulatory agenda in terms of scope and priorities. There were 17 items, there were 17 items on the Obama regulatory agenda, and if you take out the 3 deregulatory rulemakings in this one, we've got 15. So it looks pretty similar to what we were seeing under the Obama administration. All that to say that it's a mixed bag, and the Trump administration, so far anyway, is not, in the OSHA world, is not following the deregulation agenda that it promised in the campaign. Let me focus on a couple of rulemakings that I think are probably important to a number of you on the telephone. First of all, the e-record keeping rule. That, I would say, certainly would be cast as a deregulatory rulemaking. I'll talk about it in just a minute. HAZCOM is, there are going to be additional compliance obligations created by the HAZCOM standard that is being drafted by the agency. Silica is overall probably, if this goes through and OSHA finalizes that rule, will be deregulatory in nature. The beryllium standard on the general industry side, it is neutral. It is not deregulatory. It is not pro-regulatory. It is a clarification of the existing rule that was promulgated in 2017. However, on the construction and shipyard side, certainly that rule that is in proposed form right now by the agency is deregulatory. And then lockout tagout, a surprise rule that is certainly pro-regulatory, if you will. Let me run through those. We picked these out because we know who's on the phone and we know the issues that they're facing. So we want to talk about a couple that are going to impact you guys. The e-record keeping rule. OSHA, as many of you know, issued a notice of proposed rulemaking in this past summer, July 30th, 2018, which scaled back the e-record keeping rule that had been promulgated by the Obama administration. It scaled it back in two ways. One, it eliminated the requirement for large establishments, and remember those are establishments with 250 or more employees, to submit annually the 300 logs and the 301 incident reports. So it was a scaling back for sure. In addition, they eliminated the requirement to submit employer identification numbers. What probably, though, is most significant about the e-record keeping proposed rule is what it didn't do. What it didn't do is it didn't eliminate the obligation for large establishments, 250 or more, to submit their 300 A's on an annual basis. So those entities, large establishments, are not out from e-record keeping. It's just that the scope of what they have to submit through the electronic portal is less. The 300A must still be submitted. The other thing that it didn't do is it did not it did not put any sort of prohibition, regulatory prohibition, on the publishing of the data that is collected through the e-record keeping rule. And as many of you may know, there is activity by public citizen to collect the information that is being submitted to OSHA through the e-record keeping portal through a Freedom of Information Act, or many Freedom of Information Act requests. So there are multiple requests out there. Right now, the agency's position on those requests is that it is not turning that data over because it would disclose basically enforcement techniques. So right now, we have nothing in the Notice of Proposed Rulemaking that deals with publishing data. The final thing that it doesn't deal with, and this is probably the most significant, is the anti-retaliation provisions, the safety incentive programs, the drug testing requirements that are created by the e-record keeping rule. That was not touched by the Notice of Proposed Rulemaking. HAZCOM, very, very quickly. As you all know, HAZCOM, there was a major reform done to the Hazard Communication Standard in March of 2012. That standard was promulgated in order to harmonize the HAZCOM standard with the globally harmonized system for classification of labeling of chemicals and labeling that was passed by the UN in 2003. That GHS that was passed by the UN is a living document. It continues to evolve, and we promulgated HAZCOM in 2012 when GHS was on Rev 3. GHS is now up to Rev 7. There have been many changes to GHS. So OSHA is planning on doing a revision to HAZCOM to update HAZCOM to align it with the current version of the GHS. By the time OSHA completes this rulemaking, it's likely that the GHS will have moved on, but nonetheless, they're going to at least bring it closer to compliance with, or to alignment with GHS. The other thing that this proposal is going to do is, you know, the agency's had a couple of years now under its belt of enforcement of GHS HAZCOM 2012. The proposal is designed to identify those issues and deal with those issues that came up in interpretations that were issued, gaps in the regulation that were not clear from HAZCOM 2012. OSHA's now looked at that. They've been enforcing that. Companies have written in asking for interpretive guidance, and they will formalize that guidance in the form of regulations in the proposal. This is what you ought to look out for. In the areas that we understand OSHA in particular is going to change in HAZCOM 2012, they are going to focus, in the proposal that's upcoming, they're going to focus on flammable gases, desensitized explosives, aerosols. They're also going to update their guidance on new hazards, so Section C, Appendix C will be impacted. And they also apparently are doing some work on the SDS. They're thinking of making some sort of revision to the Hazard Identification Section 2 the firefighting measures, Section 5, the handling and storage, Section 7, and the physical and chemical properties, Section 9 of the SDS. So nothing right now, but keep a lookout for those and we'll keep you updated. Beryllium, very, very quickly. OSHA, as many of you know, promulgated the beryllium standard 11 days before the Trump inauguration under Obama. That standard applied to general industry, construction, and maritime, all three sectors. There were challenges filed, all consolidated in the 8th Circuit. 6 months after the promulgation of that rule, OSHA, in quite a surprising move, pulled back and repealed and withdrew all of the provisions, all of the ancillary provisions of the comprehensive rule applicable to maritime and construction, but for the new PEL and the new STEL. So the new PEL and new STEL apply to maritime and construction. Everything else is gone. Quite controversial. Undoubtedly, there'll be lawsuits over it if OSHA finalizes that proposal. That was a very big deregulatory move, probably the biggest we've seen by this agency under Trump. On the general industry side, they also made some changes, but those were not deregulatory in nature. There was a direct final rule that was issued this past May, finalized in June, that dealt with simply clarifying the exception for trace beryllium, and there's a current notice of proposed rulemaking that will, for which comments are still being submitted up through February 9th. Again, further clarification of the rule that was promulgated in January 17th. It is not a major deregulatory action by any nature. It is simply designed to help employers comply, to help OSHA enforce, and to help employees understand the new comprehensive rule. Very, very quickly on Silica, one major change is being contemplated by the agency, and it applies in the construction Silica rule only. It is to Table 1, as many of you know who are dealing with construction Silica rule. Table 1 allows employers to avoid doing an exposure assessments and also PEL compliance as long as you are using the control measures that are identified in Table 1 for the specifically identified tasks or the tools that are identified in Table 1. The change that OSHA is contemplating is simply an expansion of Table 1. And you know, I think it would be, you could categorize it as deregulatory in nature in the sense that it will add tasks and tools to the table, and it will ask, potentially anyway, add control measures that can be used in lieu of the current existing control measures for the tasks that are already identified in Table 1. So it will expand the way employers have to avoid doing the exposure assessments. Final change that we want to bring to your attention, the rewriting of LATO in a very, very significant way. And this is probably, I would say, probably the most crafty act by this administration, using the Standards Improvement Project, which is a long-standing project, I think, begun under President Clinton. We're at stage 4 of SIP, the Standards Improvement Project, which is really designed to just update outdated portions of standards, make non-controversial changes, minor changes, nothing major, because it is, you know, you're not taking using the APA to do a full rulemaking on a particular rule change. However, in SIP 4, OSHA has proposed, and this has moved along quite a bit. It's now actually at OMB for approval to go back to the agency to finalize. We're at the final rule stage of this. OSHA is proposing to delete the words unexpected energization from the LATO standard. As those of you who deal with the LATO standard every day know, those are pretty key words in the standard. And it is a clear effort to deal with the Sixth Circuit GM Delco case that was issued in 1996 that essentially made clear that that language means something in the standard. What it means is that the LATO standard applies only where it is unexpected that the machine or tool might energize or release energy in a way that hurts the employee working on it. If there are signs, clear signs to the employee that the energy is going to come back to the machine, that it's going to energize, so like for instance with alarms, like for instance if the only way energy can come back to the machine is if the service person working on it has the plug in his hand and he knows that he's going to plug it in, then those activities are not covered by LOTO. But that is not what will, but OSHA is trying to expand the LOTO standard through this SIP process. So we wanted to make you aware of that. We'll certainly keep you updated through our webinars during the course of the year on that one. Okay, that's all I have to say on the non-deregulatory nature of what's happening at OSHA right now. And I'm going to turn it over to Micah Smith, who is going to talk about some significant cases to be decided in 2019.
Thank you, Kate. If you were excited to hear about deregulation, I know you're going to be excited to hear about the cases that we think we may get decisions on, that we expect to get decisions on, and some that we hope we'll see some decisions on. So we'll dive right in. The blockbuster, if we get it this year, which we do expect a decision, could come from the Supreme Court in the case of Kaiser v. O'Rourke. Actually, with a change in the acting administrator at the top of the VA, it's now appears to be captioned Kaiser v. Wilkie. This is not an OSHA case, but it has the potential to affect administrative agency actions across the government. This case will be argued this term. The Supreme Court just granted cert last month, so we expect it to be heard likely later in the term, with a decision most likely to be issued by the end of June. There's always, of course, some risk that it won't follow the standard timeline, but that's what we're expecting. If you've read a little bit about this, you know that we're talking about agency deference. The good news, bad news on this particular case is it is very unlikely to have a big effect on Chevron deference. If you follow these things, you know that Chevron deference typically focuses on an administrative agency's ability to interpret statutes passed by Congress. It will, however, likely have a big effect on what we call our deference, also sometimes called Seminole Rock deference, which deals with agencies' ability to interpret their own regulations. So not something that Congress said, but to go back and give some clarifications on what they had previously said. So just very quick background so you sort of understand what's going on. This case involves a veteran who was treated at the VA. I believe he's a Vietnam vet, received some treatment back in the 80s, was not compensated for certain injuries. He came back later for more treatment, and they found some additional records that were seemed to be involved in the case. I'm trying not to use the word relevant because this whole case turns on what the word relevant means. The VA said that they couldn't go back and provide some back compensation for these injuries because the records that were involved were not, quote, relevant. The VA had not previously defined what relevant meant, but through the administrative litigation, the administration defined relevant as something that was essentially dispositive of the issue. It was the first time that this particular interpretation was out there, and so the petitioner, the veteran, challenged that decision, denying his back compensation for his injury, and the case has now climbed all the way up through the circuit court and will reach the Supreme Court this term. So what this really boils down to is whether the our deference doctrine is still something that the Supreme Court thinks should be out there for this kind of situation. So do we want an agency to choose whatever non-arbitrary definition it wants to use for a particular term that it has proposed or put out there in one of its rules? This is a huge question, and it affects OSHA in ways that you can see if you look at agency action over the past several years. If you look at what OSHA has done when they do things like reinterpreting guidance for the PSM standard, issuing new interpretations. Sometimes they'll come back and redefine terms. They have always argued that they are permitted to do these things, that they're permitted because they are the agency. They're permitted to reinterpret or interpret for the first time their own regulations because of our deference. And so this is something that most agencies rely on, and it's just a normal part of everyday life. However, the plaintiff in this case and quite a few activist groups, industry associations, have argued that agencies need to be reined in, that we need to have a judicial review of these kinds of reinterpretations and interpretations, that the agency ought not be able to make the rule and then also later interpret or reinterpret that rule themselves. So that's essentially what's on the table. This will be a very interesting ride, in part because it does not, this particular case doesn't have the political connotations that we might have expected if this had come up as a challenge to, let's say, an EPA action or maybe even an OSHA action. It's somewhat politically neutral because it's the VA. Both parties are somewhat sympathetic here. There's no clear left-right divide on who should win, as far as I can tell. So it will be an interesting slate for the Supreme Court to act here. So keep an eye on this one. As we said before, we are likely to see some development in the our doctrine. So whether agencies can interpret or reinterpret their own regulations, but we are unlikely to see any movement on the Chevron deference, which is to say whether agencies can interpret what Congress meant when they passed a statute. So keep your eyes on this one. This is probably the big one if we get it this year. Otherwise, coming back to something you've heard about several times during this webinar, e-record keeping cases. We won't go into detail here because it's been discussed quite a bit already in the webinar. There are, think of this in two sets. The first two cases listed here, Texo ABC/AGC, and then also National Association of Home Builders. In both of these cases, the plaintiffs were challenging OSHA's new e-record keeping rule on slightly different bases. Both of them are stayed/administratively closed, pending the outcome of OSHA's final rule, where they promised to modify the new e-record keeping rule. The proposed, as Kate mentioned, the proposed rule didn't seem to address the concerns of these litigants. So we expect that if the final rule that comes out in the near or near-ish future stays in the same vein and does not address those rules related to anti-retaliation and other issues, that we think that the plaintiff will, particularly in NAHB, but possibly also in the Texo case, will ask to reopen or to or continue the litigation. So watch those if the final rule doesn't come out the way that we expect to. The second half here is Public Citizen v. DOL. This is the case that Kate was referencing related to public citizens' FOIA request and a desire to get access to OSHA 300A data. OSHA has denied the request initially based on the FOIA exemption for active law enforcement investigations, but in a very recent filing, they expanded that and issued a new reasoning for denying the FOIA request, which is the confidential commercial or financial information exception to FOIA. This is particularly interesting because that would, if they win on that argument that they don't have to produce this because it is confidential commercial or financial information, that would be probably a permanent exemption such that no one would ever be able to get this data on a FOIA request. So right now, I believe it was last week, this case has gone through, it's been somewhat sidetracked or reassigned to a magistrate for case management. That may slow down the process a little bit, but we do think that we'll get to some sort of an outcome later this year, most likely. All right, switching gears a little bit, we've been talking about things in district and circuit courts. Now we are switching focus to those things that are only in OSHRC. We'll talk about several cases, but the one we wanted to cover in most detail is one we've been following, Secretary of Labor versus Wynnewood Refining. This is one of 3 PSM cases that we had been tracking for several years. The other 2, BP Husky and Delic, have been decided. This is the next one, and it's sitting waiting for a decision from the Review Commission. Without going into too much detail, this case is about an explosion in a boiler unit, in a utilities unit. It was not what we would normally consider to be part of a process. The company did not consider it to be PSM covered. We think most people in the industry would have agreed that it shouldn't be PSM covered. OSHA issued repeat and serious violations. The ALJ affirmed in February 2016. The case has been appealed to OSHRC and was fully briefed more than 2 years ago. So it has been sitting waiting for a decision from the Commission for quite a while. The key issues here are really relate to coverage of the PSM standard. The main facts that we think are important are how the boiler was connected to the process. It would seem that there's no argument that this particular equipment should be PSM covered because of its own contents. Instead, it really relies on its connection, its co-location with other PSM covered equipment. So another key issue is that the refinery voluntarily implemented certain PSM elements in an attempt to increase safety in the plant, and the ALJ used that voluntary use of PSM elements against it to firm up the decision that it should be actually covered by the PSM standard. So we'll keep an eye on this one, and I'm sure if you are involved in the PSM covered industries that you'll hear more from us on this in the near future, but keep an eye on that. Switching over to just a selection of other cases that are currently pending before OSHRC. The way that OSHRC works is that when they grant review on a particular case, they will have it briefed up as much as they want. Sometimes they'll grant a request for oral arguments. And once those things happen, it is entirely unclear how long it will take the Commission to issue a decision. With the 3-member Commission fully filled out right now, they have been doing a great job of clearing the backlog of cases that had grown to a quite long list in past times. But we just don't know whether we can expect a decision on 1, 2, 3, or all of these cases in the next month, year, or 5 years. So we flagged some of the more interesting things here just so you can kind of see what's coming up. The first 2 cases here relate to the General Duty Clause, which I think Erin covered to some extent previously. There are also a number of other cases. I think I counted about 6 or 7 pending OSHRC cases related to the General Duty Clause. This may be a signal that the Review Commission is going to do something big, or is really giving some deep thought to the General Duty Clause, their cases on it, but it's unclear. So we're going to keep a close eye on these General Duty Clause cases. Because of that, there may be some major movement that affects us all a lot, or not. So 2 of the most interesting here are Integra Health Management, which relates to workplace violence prevention. We've talked about that previously. You've heard a lot about it. The other significant one here is the SAIC case, which related, of all things, related to insufficient drowning prevention for a sea lion trainer. I know what you're thinking. This is just another SeaWorld case. Actually, it's not. It's a sea lions used for military applications. So if you want an interesting read on some programs that the military and military contractors are doing, I recommend this one. I think it relates to the Mark 6 Sea Lion program. Another one we didn't list here, which I'll flag because it was argued in front of the Review Commission. They actually granted a request for oral arguments, was the Sturgill case. It relates to heat stress. So those 3 are some of the most interesting. There's also a nice Waffle House case with General Duty Clause implications related to failure to clean a grease trap with sufficient frequency. So those are a couple there. A few other here interesting things. There was the OSHA Detective Agency case wherein OSHA alleged that there was a PPE violation, so it's close to a general duty clause but not quite, for not providing a ballistic resistant vest to a guard killed in a robbery. And that could be a very interesting case as it relates to hazard recognition and how much employers are supposed to know as it relates to possible or likely hazards that may come up. There's a particularly interesting discussion in the Suncor Energy case related to whether construction or general industry standards applied to certain work. So, that is an ongoing issue that is much discussed at many points, whether you fall under the construction or general industry standards. This case presents an opportunity for the Review Commission to give some better guidance to make a decision that we'll be talking about. And then the last one to flag here is the Dover High Performance Plastics case. This one, guarding cases, sometimes they are a dime a dozen because they're very fact specific, and what you learn from one may not apply to the next guarding case. This one we flagged as particularly interesting because it is a willful guarding case, and the willful classification here was based on a previous citation issued to the employer several years earlier, early enough that it did not seem appropriate for the agency to issue it as a repeat citation. But OSHA still argued that that previous citation put the employer on notice and gave them this heightened awareness of the guarding requirements. So there are some very specific facts there that may drive the decision, but we wanted to flag that there's an interesting case there on willfulness that you could learn something from in the when that comes up. All right, last thing before we go, it's not actually an OSHA case, but Eric talked already about EPA's RMP rulemaking and what has happened in the past, the big DC Circuit case related to the delay rule. We are watching for, as EPA is expected to finalize their reconsideration rule that will essentially roll back the RMP amendments. We will be expecting some challenge. However that turns out, we think that one or both sides will file some litigation. We've included here a basic timeline of what's happened with EPA publishing the final rule for the RMP amendments, delaying it, publishing the proposed rule to rescind the RMP amendments called the, quote, reconsideration rule back in May. So what happens next? We are waiting. EPA has promised to roll out that final rule in January or February of this year. Of course, with the shutdown, as was previously indicated by Amanda, EPA is partially shut down during this government shutdown. That's likely pushing off that time frame. But keep an eye on that. When it lands, we'll look for litigation. What we're trying to read from our 2018's tea leaves was the language in the DC Circuit's decision in Air Alliance Assign. They were very critical of EPA, seemed to say that they were going outside their mandate, not doing what Congress told them to do when Congress passed the Clean Air Act amendments. So is it a sign that the DC Circuit might stay the reconsideration rule, actually keeping the RMP amendments in effect until the litigation is over? Those are issues that we'll watch for in litigation. Last thing, if you are covered by the RMP amendments, interim enforcement, as far as we know, there's no clear guidance from EPA on whether they will enforce. It seems unlikely that they would enforce a rule that's likely to be rescinded, but at the same time, regional offices run their own enforcement actions typically, so we could see formal or even somewhat informal enforcement of the RMP amendment provisions. So that's it for potential litigation in the new year, so I'll pass it off to Andrew on the West Coast to talk about Cal OSHA issues in 2019.
Thank you, Micah. My name is Andrew Sommer. I'm a partner with the California practice of Conn Maciel. Last but not least, I will be discussing here key Cal OSHA developments to look out for in the coming year. Just a little about myself. I have been practicing for over 20 years. I head up the OSHA practice, advising employers on workplace safety issues, on handling inspections, and then also representing employers in OSHA appeals up and down the state. I also represent employers in other state plan OSHA litigation, for example, in Oregon and Washington State as well. And like Erin, I have a hybrid practice where I also advise employers on general employment matters as well as represent them in civil litigation involving employment-related claims. Well, let's just dig into this here. There are several key developments. There's some recently finalized rulemaking that I wanted to address with you, as well as proposed rulemaking that has been in the works for a couple of years and that we expect potentially in the next year to result in final approved rules. There was the question about the MIP standard, which is the Hotel Housekeeping Musculoskeletal Injury Prevention Rule. That is a subject that we don't have time for today, but I would be happy to discuss offline that new rule or any other OSHA issue with any of you. But starting off here, a couple rules that are in the works here that we expect to issue soon are one, the Workplace Violence Prevention General Industry Rule, as well as the Indoor Heat Illness Rule. And what's interesting about these two rules is that they're really an extension of existing standards under OSHA. OSHA has already developed a workplace violence prevention rule for healthcare, and they're seeking now to extend it to essentially all employers as a general industry rule. And then likewise, the OSHA has a outdoor heat illness rule that has been in existence for some time and has been a key priority by the agency. And now the agency, through rulemaking, is seeking to extend that to indoor settings such as warehouses. Also, there have been recent rules that have taken effect regarding electronic record keeping and an extension of the statute of limitations for record keeping in connection with that legislation and rulemaking. But let's start off with the workplace violence prevention plan that's being developed for the general industry. And what's interesting is California has placed a tremendous focus on workplace violence prevention. We have gone beyond requiring that the injury and illness prevention plan incorporate components of workplace violence, but actually developed an independent rule for healthcare. Now the state is conducting a review of a rule that will impact the general industry. And so this rulemaking has been in the works for a couple years now, since 2017, and it falls on the heels of the workplace violence rule for healthcare that was enacted. And so in many ways, this general industry rule will likely be similar to the rule that was adopted for the healthcare industry. And so there's several key components, but in a nutshell, really what you're talking about is having to have a written program that outlines all of the key components, which includes procedures for accepting, responding to workplace violence reports, procedures for responding to workplace violence emergencies, training of employees, and procedures for identifying workplace violence hazards. And I have developed these plan documents for healthcare, and they're quite labor intensive. There are a lot of very detailed requirements. It has to be adopted in a way that it recognizes the unique nature of the operations of the employer and the workplace violence incidents that may arise there. And there's a number of different training requirements for both supervisors and employees. This rule has not yet been finalized, but I would expect to see a final rule adopted in the next year. So let's move on to the Indoor Heat Illness Prevention Rule. This rule has actually been mandated by the California legislature, And so the California legislature required that the agency commence rulemaking over these indoor heat illness standards. And prior to this rulemaking, there was a precedent decision by the CalOSH board ruling that an employer's injury and illness prevention program was deficient because it failed to provide training and instruction to supervisors on the hazards of indoor heat illness. And in that decision, it related to an indoor warehouse. And so that was really the authority that we were operating off of. Now the state is seeking to go one step further and to require a detailed indoor heat illness rule that in many ways will be similar to the outdoor heat illness rule that's presently in effect. And so what's interesting about this rule is that it has some key differences. One is that it does recognize that personal heat protective equipment may be required where there are no engineering controls to get the temperature down below 82 degrees, which is a threshold for this new standard. And it discusses examples of what such personal heat protective equipment may be, such as garments that may reduce heat illness, essentially create a cooling effect. And under the present draft of the rule, the employers that would be covered would be those that have work environments that where the temperature equals or exceeds 82 degrees. And so, as indicated, this rule is in draft form. They're accepting comments through November 2000, or they were accepting comments through November 2018, and there is a possibility that this rule will be finalized this coming year. And then also, this rule does provide many of the same components as the outdoor heat illness rule regarding requirements to provide water, emergency response, training, cool down opportunities, and developing a detailed heat illness prevention plan. And then one rule that has already taken effect relates to e-record keeping. There was some discussion previously of that requirement federally, and the OSHA has required that the states adopt a similar e-record keeping standard. CalOSHA was slow in adopting any standard, and then in September of 2018, Governor Brown signed a bill directing CalOSHA to monitor OSHA's e-record keeping rule. And essentially based on that legislation, the agency, CalOSHA, proceeded to develop a rule requiring the submission of electronic data. So this essentially the 300 logs. And there was emergency legislation that was proposed, and there should be a follow-up to that. And under that new rule, there is a requirement for covered employers to submit their electronic data. And essentially, the state is requiring that the record keeping be submitted through OSHA's online portal. But what's been interesting is that in the new legislation, it has stated that the state must monitor the OSHA's e-record keeping rule. And if the state determines that OSHA has eliminated or substantially diminished the electronic record keeping rule, CalOSHA is required to convene an advisory committee to evaluate how to implement the changes necessary to protect the goals of the proposed federal rule issued under the Obama administration. So essentially, if the Trump administration scales back this e-record keeping rule, we could very well see independent legislation in California seeking to adopt the existing OSHA e-record keeping rule. And then in a nutshell, what's happening now in California is that covered establishments are required to submit their 300A logs or data through the OSHA injury tracking application portal. And the covered employers that must submit this data are establishments with 250 or more employees, except to the extent they're exempt under California regulations, establishments with 20 to 249 employees in certain designated high hazard industries, and establishments that are otherwise notified by Cal OSHA to submit injury data. And there's been this catch-up provision that has, on a very short time frame, required that covered California establishments collect the 2017 data and submit it by December 31, 2018. So that should have already occurred. And then the next year's data for 2018 must now be submitted by March 2nd, 2019. And then another interesting wrinkle here is that the legislature has slipped into this new California law over e-record keeping a very significant change to the statute of limitation for record keeping violations. So in the past, there was a 6-month statute of limitations that applied, and that language was modified to include language as indicated under the first bullet that an occurrence continues until, for record-keeping purposes until it's corrected or the division discovers the violation or the duty to comply with the violated requirement ceases to exist. And so what's happened is in the past there was the Volk's decision that was superseded to a degree by the Obama administration rulemaking, and also which was recognized under a significant Cal OSHA precedent decision, that essentially you have a 6-month time frame in which to file a citation over e-record keeping or record keeping violation. That has changed now, and what we are faced with is a 5-year statute of limitations, which really heightens any exposure you may have to any sort of defect or an infraction with the record keeping. And so we'll see. We may end up seeing many more record keeping citations down the line. They to date have not been as significant in California in light of this limitation.
Yeah, I would say, Andrew, a combination of the extending the statute of limitations by 4.5 years and the new repeat violation policy in California makes record keeping a potentially significant trap for California employers now. So thank you, everybody, for joining us for our feature-length film on OSHA. I'm so sorry about how long the program went. I sent one of the comments out. Hopefully you saw. This is the problem when you only have partners presenting a program. We don't have associates to keep us in line and keep us in check. So I apologize for the length, but hopefully you found it interesting and worthwhile. It was certainly interesting to us and learned a lot in preparing materials today, and really, makes us look forward to a really interesting year, 2019, for developments at OSHA that we'll be paying close attention to. And you can see here the rest of the topics for the webinar series. We hope you can join us for all of these or some of these, or at the very least, please register for all of them, and you'll get communications from us about it, copies of slides and recordings and things like that. So we hope that you can join us the rest of the year. We'd also encourage you to check out and sign up for our OSHA Defense Report blog, OSHADefenseReport.com. That's where we'll be writing about a lot of the topics we talked about today as some of those big developments occur. Cases get decided, rules get finalized, policies get changed, things like that. We'll be getting those more or less in real time and updating you all about that on our blog, so check that out. I tried to go through and answer a bunch of questions in writing as the program was going on, so hopefully your question has been answered. If not, we're going to look at it and get back to you by email afterwards. And of course, if you have any other questions or if your question didn't get answered, shoot me an email or give me a call, or just find any of us, any of the members of our OSHA team here at Conn Maciel Carey. You can find us on our website, connmaciel.com. Here's my contact information here. Thanks everybody for joining us, and we look forward to another really fun year of webinars. So enjoy the rest of your day.